Thank you for joining Jackson Lewis as we take a closer look at the employment law trends and tactics sure to shape 2023. This installment is one of 12 concise, field-specific podcast episodes that are part of our annual forecasting favorite, The Year Ahead. We invite you and others at your organization to experience the report's legislative, regulatory, and litigation insights in full at our website, jacksonlewis.com, or listen to the podcast series at whichever platform you turn to for compelling content.
Good morning, afternoon, or evening, depending on when you're listening to this. My name's Erik Winton, and I'm a principal in the Boston office and co-lead of the firm's Restrictive Covenants, Trade Secrets, and Unfair Competition practice group. With me today are Cliff Atlas, my co-lead in the practice group and a principal in our New York City office, and Dan Doron, also a principal in our New York City office, who specializes in, among other things, transactional work and how it relates to our practice group. For those of you who have not read about this yet, I'm not sure how that could be in light of all the press, or maybe who've read about it but want a little more insight, the FTC issued a proposed non-compete rule that would essentially ban non-competes in the United States, except in limited circumstances. Now, this rule came down Thursday, January 5th, while I happen to be on family vacation in Aruba. So thank you, FTC, for that timing. Nothing like reading a 218-page PDF on your cell phone from the beach. I do want to thank Cliff, Dan, and our other team members who stepped up while I was away to learn as much as possible about the issue in order to be able to intelligently speak to our clients, colleagues, press, and all of you. And because I was on vacation, or maybe as punishment, today my role is to ask the questions of Cliff and Dan. But before I do, a quick primer on how we got to this point. Non-compete regulation has been on the radar for almost a decade now in response to stories of alleged abuse of such agreements by businesses like sandwich shops and summer camps that made a lot of news, again, about 10 years ago. In 2016, the Obama White House, with involvement and support from then Vice President Biden, issued a state call to action on non-compete agreements, which encouraged states to curb what were seen as abuses of non-compete agreements. And over the ensuing years, dozens of states responded by proposing, and in many cases passing, legislation to address some of these alleged abuses. There were multiple attempts at the federal level as well at legislation during this time period, but through today, nothing has yet even come close to passing federally. Apparently, seeing federal legislation as a dead end and perhaps not being satisfied with the state-by-state patchwork approach, the FTC, Federal Trade Commission, started looking into this issue. And in January 2020, the FTC held a full-day workshop regarding its ability to take action in this area and whether it should. I attended that FTC workshop, and during which it was clear that most, if not all, of the experts believed the FTC was going to face significant hurdles if it tried to do what it is currently doing. In July 2021, the Biden White House issued an executive order directing the FTC to ban or limit non-competes. And in November 2022, the FTC issued a policy statement previewing much of what it did last week, or at least the basis behind its belief that it should take the steps it has taken. So while it had been telegraphed pretty clearly that the FTC would look to do something on non-competes over the last several years, what was somewhat surprising is what they decided to go for: a complete ban for any worker at any compensation level under almost any circumstance, even with the negative feedback from their own January 2020 workshop. It's a real moonshot. But enough from me. Let's talk to our experts about this. Cliff, for those who have been reading about the FTC's proposed non-compete rule, should they be panicking?
No, Erik, they shouldn't be panicking. It's a proposed rule right now. It may not be finalized in its current form, and whatever rule is finalized will face significant and substantial legal challenges. There is no need to panic, but there are things employers ought to do to get their house in order in the event the final rule looks like what has been proposed.
So, Cliff, tell us, what exactly does the proposed rule prohibit?
Well, the proposed rule prohibits all non-competes, or I should say all true non-competes. Those agreements that tell an employee that they can't work in a certain industry for a certain period of time in a certain geographic area. But it also defines non-competes as other types of provisions that are de facto non-competes. So really any restrictive covenant that is overly broad could be roped into the ban. It's vague.
All right, so many of the headlines we've been seeing in periodicals, both legal and general, they talk about non-competes. You're saying it potentially applies to other types of agreements or restrictions as well. What do they mean by a de facto non-compete?
Well, Eric, the proposed rule refers to a functional test for whether a contractual term is a non-compete clause. The rule explicitly states the following: the term non-compete clause includes a contractual term that is a de facto non-compete clause because it has the effect of prohibiting that worker from seeking or accepting employment with a person or operating a business after the conclusion of the worker's employment with the employer. So whether a contractual term is a de facto non-compete will need to be determined on a case-by-case basis. The proposed rule, though, offers two examples of clauses that may, it says, be de facto non-compete clauses. The proposed rule mentions an overly broad non-disclosure of confidential information provision, for example, that effectively prohibits a worker from working in the same field after the conclusion of employment. The proposed rule also mentions a repayment of training costs provision. And, this is surprising to me, not because repayment of training cost provisions could be construed as non-competes. I think they can, and I can think of at least one New York case that did so. But it's surprising to me because even though the proposed rule is so sweeping, the FTC here has specifically focused on an issue that pretty much exclusively pertains to lower level employees.
So the two examples they give as de facto, that's obviously not all the examples. There can be other agreements that would be de facto non-competes, right?
Yes, absolutely. It could be anything. It could be broad non-solicitation or non-servicing type of provision that might be in a restrictive covenant agreement. It depends on the circumstances. It depends on the industry. It depends on the language of the agreement. It depends on the employee to whom it applies to determine whether or not it effectively prohibits that individual from working in his or her chosen field.
That's a lot of the famous lawyer answer of it depends.
It depends.
But the problem is these employers aren't going to know because you now have a proposed rule and they don't know if their agreement is going to be found to be a de facto non-compete and unlawful or not, right?
Well, exactly. And that is fundamentally one of the problems with this proposed rule. It's a rule that is so boundless, it does not give employers any guidance.
To whom does the proposed rule apply? Is it all levels of employees, independent contractors, partners, business owners? Tell us.
Well, everyone. Under the proposed,
except you and I.
Well, because we're lawyers and non-competes don't apply to lawyers to begin with. So the ban doesn't really matter for us. It's already banned. But under the proposed rule, a non-compete clause means a contractual term between an employer and a worker. And it's interesting that they chose that word because the worker can be an employee, an independent contractor, someone who's paid, someone who's not paid. So it could really be anyone who works for the employer or performs services to the employer in any capacity whatsoever. The proposed rule remarkably makes no distinction about the different roles or rules applied to employees of different roles. That type of differentiation is raised in the notice of proposed rulemaking as a possible alternative. But right now, it applies to everybody equally.
What about agreements that already exist? Contracts that have been signed maybe years ago?
Here's one of the places where I think the proposed rule is really overreaching. Yes, the proposed rule would apply to current agreements, to answer your question. The proposed rule requires that any current non-competes actually be rescinded by employers in writing. This has to be done within 180 days of the publication of a final rule. And I say 180 days, but the rule requires that a notice of rescission be sent to current and former employees within 45 days after the date of actual rescission. So if you're mathing on this, that's 225 days after the date of the final rule. That's just one of the many vague complications from all of this. But the rescission itself needs to be an individualized communication. The content of the notice must communicate to the worker that the worker's non-compete clause is no longer in effect and may not be enforced against the worker. The proposed rule itself provides a sample of such a notice, but the employer doesn't have to use that specific form of notice.
So that's the notice requirement, but I assume if the proposed rule goes forward, the employee can act like they're not bound even before they receive the rescission, correct?
Yes, I think that's right. I think the proposed rule, once it takes effect, becomes effective immediately, at least as currently drafted.
And I mean, I'm not just thinking historically, other laws that have been out there where it's one thing for the law to say, okay, these agreements or this type of provision is no longer enforceable. It's another to require you communicate to all the people who are impacted as the private employer and let them know in some kind of communication that it's rescinded. It seems like it's almost like sending a message.
Well, yes, it is sending
to the employers.
It is sending a message. And I think that, as I said at the beginning of this little segment, this is where I think the rule really is overreaching by undoing, really rewriting hundreds, thousands of contracts across the country.
Yeah, I saw one article that somebody mentioned 30 million contracts would be overwritten by this law if you do the math.
I don't know how anyone does that particular math and came up with that number, but I'll be satisfied by saying a lot of contracts need to be unwound by this rule, and that's that's really overreaching, I think.
Well, Dan's been sitting here patiently, and I have a question for him. Dan, what happens under the proposed rule if you have a non-compete that's part of a fulsome employment agreement and the non-compete was part of a bargain for exchange for, say, higher level of severance, and maybe they were represented by counsel? What happens then?
So the FTC doesn't expressly answer that question. It certainly suggests, though, that the rule applies equally to those types of agreements. So it says you simply excise the non-compete clause from even a fulsome executive style agreement. The whole rule speaks in terms of rescinding the non-compete clause. It doesn't talk about rescinding the entire agreement. And so it's not an exaggeration to say that the proposed rule effectively rewrites the agreements.
So what about if someone was given a large boatload of money as an executive as part of an employment agreement that had a non-compete in? How can how's that going to work with rescission and the consideration? Do we know what the FTC is implying there?
We don't. You could imagine a scenario where you have within the non-compete clause itself, as we sometimes do, there is a restricted period payment. And you can imagine an employer arguing that the non-compete clause, because the whole clause is severable as is, that gets rescinded. But very often, these bargained for economic terms exist in separate several portions of the agreement. And so the way I read it, you simply excise the non-compete clause and everything else stays in place, which is to say that it really undoes the bargain that is struck in a dynamic give and take negotiation where the non-compete is one point of negotiation among many others, including economics.
Yeah, I mean, I don't think you can go back and figure out when we were negotiating this, what was the value of the non-compete in the full package given to the CEO, right? That's going to be impossible to do.
Exactly. That's exactly the case, and all the more true when it comes to striking non-compete provisions out of purchase and sale documents.
So going back to because executives are the ones that, when we move down the line and maybe we have a rule in the end, or maybe we don't, or we have some revised rule, I have to think that executives, there's going to be a better argument to at least keep non-competes for executives. But as currently constituted, does the rule or any of the exhibits attached to the rule tell us how the FTC views this issue in terms of, do they think the executive gets to keep the compensation but still not be bound by the non-compete?
The only view of the FTC we have on this is in their model rescission notice, which the rule does not require employers to use this model notice, but the model notice contains language that says, quote, the FTC's new rule does not affect any other terms of your employment contract. So, it's from that we can, extrapolate what the FTC's view of this is.
That's just remarkable. Dan, is there any way to draft around this type of problem so that the executive doesn't get to keep all the compensation and not be bound by the non-compete?
There may be, and we've been discussing a lot of these ideas internally. But when you get to drafting, it's really highly individualized and should really be done in consultation with counsel and mindful, of course, of any client's risk tolerances.
So is that something that if you are currently an employer and you have an executive employment agreement with your CEO that has a non-compete in it, is that something that you should be looking at right now to see if you might want to take some options?
I think it's definitely worth having a conversation with counsel, also weighing the risks that what you wind up with at the end of the day is anything that looks like the proposed rule. I mean, I think that's one of the things you have to balance here.
What about non-competes in the context of a sale of business? I mean, historically, that's across the country. If you sell a business, it's pretty easy to enforce a non-compete because otherwise, what are you buying?
There is a proposed sale of business exception in the proposed rule, but it's extremely narrow. It applies only when the party to be bound owns 25% of the ownership interest in the entity. Again, this applies not only to non-competes in future sales, but also in sales that have already closed. And 25% seems like a pretty arbitrary threshold, paying no attention to the overall business valuation or how much goodwill may be attributed to any particular shareholder. If the proposed rule becomes final and survives legal challenges, there would likely be serious fallout and unintended consequences in M&A. And it's ironic that while the FTC asserts that the proposed rule furthers competition by freeing individuals to start a competing business, the fact is that the proposed rule will actually devalue many of those businesses upon exit.
All right, so it's one thing to rewrite an agreement between one individual and a company that has a non-compete in it. But you're saying that as currently constituted, the proposed rule would actually rewrite the agreements in a sale of business context where a company may have spent tens of millions or more dollars to give to the founders in exchange for them sitting on the sideline and selling the business, and that would now be rewritten so that they could compete even though they've received all that money.
That's exactly right. And, needless to say, this would be massively disruptive.
Yeah, I mean, it's not a legal term, but that sounds bonkers. Cliff, well, what about the benefit plans where competition isn't prohibited per se, but there's a forfeiture of some type of deferred compensation if the employee does compete?
Yeah, Eric, this is an area where things, again, are currently unclear. Employers use a variety of carrots and sticks and have over the years to protect their legitimate business interests. while providing substantial compensation to key employees. These come in the form of long-term incentive plans, stock plans, restricted stock plans, and the like. And these plans typically have included forfeiture provisions where if someone leaves early, they would forfeit some shares that are invested. Maybe they forfeit some shares that are vested. And maybe if they compete, they also will forfeit those shares. And in addition, will be subject to clawback of equity gains. And so those are among the types of sort of complex compensation systems that we've seen. Plus, there are some other non-competes that will be tied to severance plans, which may themselves be governed by ERISA. So, it's remarkable that the proposed rule in its current form does not take any of this into consideration. If such plans are ERISA plans, I don't know how a rule promulgated by the FTC can supplant ERISA in that circumstance.
I mean, it sounds like the FTC doesn't know either, because they don't even make any type of reference to ERISA in this respect, do they?
They don't. And it's going to be part of the subject of what I think will be pretty substantial comments that are coming.
So speaking of comments, Dan, where does the proposed rule stand today?
The proposed rule is open for public comment until at least March 20th. Members of the public could request an extension of time of the comment period, and we wouldn't be surprised if that happens. We're likely to see a very large volume of comments when all's said and done, and it's going to take the FTC some time to get through it all. So far, comments have been coming in at a pace of more than 300 a day, and that pace is accelerating. So over the last few days, they've been coming in at around 600 a day. Once the comment period closes, the FTC can do a few things. It can reopen the comment period. It can issue a new proposed rule. It could terminate its rulemaking, which seems unlikely, or it moves on to a final rule. And when it does that, the FTC is not required to address each and every comment that was made, but it is expected to address significant comments. At the end of the day, it could easily take the FTC a year or more between now and when it publishes a final rule.
So if the FTC sticks to its guns and goes forward with the proposed rule or something close to it, what are some of the legal challenges it's likely to face, and how do you think that those might play out?
Yeah, it's virtually certain that if the final rule looks anything like the proposed rule, you will see legal challenges. And we get into some of the more technical issues on our blog. But the upshot is that the challenges here are going to center on the FTC's authority to engage in this kind of rulemaking, as opposed to enforcing alleged abuses on a case-by-case basis. And it's also important to keep in mind that the litigation over this rule is really going to be the battlefront of the FTC's rulemaking authority, and because it implicates a lot of areas that go well beyond non-compete. So you have a lot of people watching this and a lot of stakeholders with a vested interest in what the outcome is on the question of the FTC's authority.
So when are we likely to see this type of litigation?
Most likely, it would take place sometime after the publication of a final rule, but before the 180-day period that is, the compliance date.
And we're all non-compete lawyers, so the question we have on our mind is there going to be an injunction? If we can be able to stop this thing with an injunction?
Well, I think you're going to get a sense of deja vu thinking back to 2016 when, employers were preparing for implementation of the new DOL overtime rules. And just a few days before that rule took effect, the rule was enjoined on a nationwide basis by a federal court judge in Texas. So I think some scenario like that is absolutely within the realm of how we think this could play out.
So, Cliff, what are the takeaways?
Well, it's unclear what the FTC's proposed rule will say when it's finalized. Not only has the FTC invited comments on all aspects of the proposed rule, the FTC itself raised a number of possible alternatives in its own notice of proposed rulemaking. Starting at page 136 of the big pile of paper that they published, the FTC outlined 4 varieties of alternatives: a categorical ban for low-wage workers and some sort of a rebuttable presumption for others, a categorical ban for low-wage workers and no impact for others, having a rebuttable presumption of unlawfulness for all workers, which, kind of looks like a rule of reasonableness that's currently used broadly across the country. And the 4th is having a rebuttable presumption of unlawfulness for some workers and no impact on other workers. Now, all of these sort of sound kind of like the same gobbledygook, but it does look like the FTC is considering having different rules for different levels of employees. So, as mentioned, the FTC is inviting comments. Employers who are interested in trying to shape this rule one way or the other should submit their comments. The final rule could be the same as the proposed rule, could be some version of the alternatives, or as noted, all of this could be held to be beyond the FTC's rulemaking power. But even absent the proposed rule, the FTC, as Dan mentioned, can still bring complaints to punish abuses, as they did recently. The day before the proposed rule was announced, the FTC announced 3 consent orders resolving different enforcement actions. We also think that the FTC's focus on non-competes could cause courts to scrutinize non-competes that come before them a little bit more carefully than maybe they have in the past because of the public sentiment around it.
Well, certainly if you're a litigator, you're going to try to use this if you're defending against a restrictive covenant.
Most certainly you will try to use it. Even Delaware recently has taken a harder line on both employment and sale of business non-competes. So, ultimately, this is a good time for employers to consider what agreements they have in place, whether they are tailored to their legitimate business interests, and whether they are drafted and used narrowly. This is consistent with advice that we have provided for years, frankly. Drafting well to avoid even unintended overbreadth is more important than ever, both for employment non-competes and sale of business non-competes.
So there you have it. Despite the onslaught of press over this issue, the sky is not yet falling as to non-competes. There's no need to panic or rush to make across-the-board changes, but it is an opportunity to read the room and address any potential issues you may have as an employer with respect to this subject, so that if, when, whatever may happen happens, you'll be best prepared for whatever the final outcome may dictate. Thanks, Cliff. Thanks, Dan.
Thank you.
Thank you.
And thanks all of you for listening.
Thank you for joining us for the Year Ahead 2023 Special Edition podcast series. Please tune in to the next episode, where we will continue to tell you not only what's legal, but what is effective. All of our Jackson Lewis podcasts are available to stream and subscribe on Apple Podcasts, Google Podcasts, Libsyn, Pandora, SoundCloud, Spotify, Stitcher, and YouTube. For more information on today's topic, our presenters, and other Jackson Lewis resources, visit jacksonlewis.com. As a reminder, this material is provided for informational purposes only. It is not intended to constitute legal advice, nor does it create a client-lawyer relationship between Jackson Lewis and any recipient.